Good morning and welcome to an oral argument session of the 5th District Court of Appeal. I am Judge Cohen, and I have the honor of being joined on the panel today by Judge Wallace, Rand Wallace from Orange County, and Judge Jim Edwards from Seminole County. We are on YouTube. We are both streaming and recording this. My understanding is that our viewership is just soaring up to maybe like 10 people since March. So be aware of your audience. So we begin this morning with case number 19-2370, Paul Elias versus State of Florida, case number 19-2370. So, counsel, if you are ready to proceed. I take it you both can see the clock. Any problems?
Yes, Your Honor.
Okay,
yes.
Go ahead.
Good morning. May it please the court, Michael Lefferman on behalf of the appellant Paul Elias, and I'd like to reserve 5 minutes of my time for rebuttal.
Okay.
I'm hoping to focus my time this morning on the claims 1 and 5 in the briefs. I'll answer any questions that the court has regarding the other claims. And of course, for any of the claims that I'm not able to address during the oral argument, I'll rely upon the arguments made in the briefs. So let me begin with claim 1, and that's the discovery violation. The defendant's theory of defense in this case was that he did not knowingly possess any of the images in this case. And there was some testimony in the record from both him and his wife that years earlier.
Let me stop you and give you my concern with the issue 1, because I can tell you that I am very sympathetic in terms of, it appears to me that we have a prosecutor in this case who was well aware that the detective, and I think it was Detective Ernie in this case, had changed his testimony, had gone and done additional work, had changed his testimony, asked questions about that at deposition. So, and at trial, the prosecutor asked specific questions going down that line. So the prosecutor was well aware that this detective had changed his testimony and yet did not fulfill the discovery obligations and advised the defense of the change of testimony, and then exacerbated it with the cross-examination of the defense expert. So all that said, here's my question to you. How do you think that you had a timely objection to that by trial counsel? Because it looks to me like there was no contemporaneous objection, that the detective testified to it without objection, without motion for mistrial, without a motion for a Richardson hearing. And it wasn't until the parties came back after lunch that first objection was raised. So how do you meet your preservation of error issue in this case?
Your Honor, the remedy, of course, would have been a continuance. So whether that continuance would have been given the moment Detective Ernie...
I'm not talking remedy. I'm talking whether you've got a preserved error.
No, I understand. But I'm saying that to respond to your question. So if you'll give me an opportunity, the remedy would have been a continuance. So whether that remedy would have been addressed by the trial court the first moment that Detective Ernie mentioned Flickr and said that he had experience, which is in contrast to his deposition testimony, or at the conclusion of his direct exam before cross-examination when it was brought up. There was no harm to anyone in this case by the failure to bring it up when it was brought up. And this court is well aware.
But you have to have a contemporaneous objection, and you didn't have a contemporaneous objection. So, yeah, and under your theory, that really swallows the rule of the necessity for a contemporaneous objection, because you could say that in any case.
Well,
listen, the trial judge ultimately addressed it, even though it wasn't timely. So no harm, no foul.
Well, that's part of it. So the other part of it is it was during Detective Ernie's testimony. So
Not
I
good.
think
That's not good enough.
well, yes, I submit that it is, Your Honor. The standard, it doesn't, there is case law that says it doesn't have to be within the exact sentence. It can be within a short time of when the objectionable comment occurs, number one. Number two, the whole purpose of the contemporaneous objection rule is to put the trial court on notice and give the court an opportunity to correct the error, which is why I went back to what the remedy in this case would be. Clearly, the trial court had the opportunity to do that in this case. The trial court, I acknowledge, yes, it was done at the end of direct examination. It was done before cross-examination. And the reality of a situation like this with defense counsel, it does take time to think back and say, wait a minute, he's going into Flickr. I need to grab my copy of the deposition. I'm pretty sure he said in the deposition he has no experience with Flickr. So the time that it takes for that to occur and when this objection was raised, I submit that it was reasonably within the time frame of when Detective Ernie's testimony was given. It's a couple pages later. It's certainly before cross-examination even begins. He clearly put trial counsel on, or the trial court on notice that this is an issue, and the trial court had an opportunity to timely resolve the matter. And the trial court ultimately determined that there was not even a discovery violation. If there was, it was inadvertent and there was no prejudice. Which
let's talk about the counsel. Counsel, let's talk about the remedies just a little bit. Did the defense counsel request a continuance?
Because the judge didn't grant the.
No.
The answer is no. But
okay,
the
wait a
reason
minute.
is
that's all. I just wanted to confirm that. Then the other question I have for you: the judge did offer to let defense counsel postpone cross-examination of Detective Ernie until after he had the chance to speak with defense expert, because he indicated over the lunch break he tried to reach his expert and couldn't. Defense counsel didn't take him up on that, did he?
Because it was too, he did not, but at that point it's too late, Your Honor. And the reason is because, and Judge Cohen's already mentioned it, what happened during cross-examination and re-cross-examination of the defense expert. There's no way this could be resolved in a lunch hour. This couldn't even be resolved in some type of overnight review. The defense, and if I could jump back for a second, the defense in this case was he didn't possess, didn't knowingly possess these items. The state put on Detective Ernie for the sole purpose of refuting that, because Detective Ernie said, and this is 385 through 387, and just as Judge Cohen already indicated, it's clear the prosecution was aware of these answers and the way that the questions were asked. He said, you have to select, you have to upload. There's no auto upload function from Flickr. That program was not installed on these computers. That's
counsel, I understand, and I'm speaking for Judge Cohen a little bit. We do not disagree at all that this was inappropriate. We were trial lawyers. We understand how it feels when somebody pulls something like this, but we also understand the obligation that Judge Cohen's talking about to make the objection timely, contemporaneously. And even if you come back after lunch, if the judge gives you a little time to speak with your expert, then you talk with your expert before you cross-examine, and you come back and say, Judge, now we've been torpedoed, and you present further argument to the judge why you've been torpedoed. But I know you wanted to talk about some other issues, so we don't want to get too bogged down in this one, but it's your time, spend it how you want.
Well, Your Honor, no, I'm here to answer your questions, and I want to try to convince you on this issue, because this was not fair. What happened, as you've already explained, this is not the way trials are supposed to take place in Florida. We have open discovery. The prosecution was well aware of what was happening in this case. They failed to advise the defense when there was a material change in testimony, and it did, in fact, torpedo this defense. The Flickr testimony specifically torpedoed the defense in this case. And how was it worse? And how would a lunch hour or overnight not have helped? All you have to do is look at page 490 of what was the recross examination of the defense expert. The defense expert had mentioned in direct that it's possible that there could be some third-party program that could have been on this computer that would have allowed these images to automatically have been uploaded onto Flickr. This is the prosecutor on recross on 490. You did this research last night and found this stuff about the plugin. Is that correct? Insinuating that, oh, for the first time, you're bringing up your testimony last night. You didn't do it.
Mr. Government, we're aware of all that. And I'm, I mentioned that in my preface to your initial questions, but it still seems troubling, the lack of a contemporaneous objection.
I understand. And I don't know that I can say much more other than at some point, I would submit that having been trial lawyers and trial judges, there's it's not easiest to be in the arena at the time this is going on. As I said earlier, you may not even remember or realize for certain that he didn't say this in his deposition. So it takes time to grab that deposition and verify it. You don't want to assert something about the prosecution that wouldn't be correct. So I submit he reasonably and timely, after having an opportunity to even confirm that in the deposition, in fact, Detective Ernie did say, I have no experience with Flickr, and he immediately brought it to the trial court's attention at that time before he even began his cross-examination, and certainly in time to allow the trial court to allow an appropriate remedy. But the only appropriate remedy would not have been some lunchtime discussion with the expert. It would have to be a continuance. And here's why I'm trying to get to this point. This is
A
the bottom of
continuance
page 490.
wasn't requested.
Well, I understand, but so if I could go a little further, the bottom of 490, did you say you saw evidence of the plugin when you did the examination of the computer? This is the prosecutor asking the defense expert. And the defense expert, I did not look for, I might have looked for the Flickr software program. I did not look for the plugin when I initially did my exam. Goes on to say he did his exam before his deposition. So the defense expert is now in a position where he's being asked, did you find any evidence of this software? And obviously he doesn't have the ability overnight to go do that evaluation. He did his evaluation of the computer in, I assume, in a law enforcement agency's office months prior to this. And so
let's talk a little bit about the other point, I didn't memorize the points of your brief in terms of which came first, but I assume it's the introduction of the pictures that were uncharged.
Well, it's that there's a mention of images in ground 2 of uncharged images. And I've argued that that's always inappropriate for a jury to hear about uncharged images. It's extremely prejudicial. I've also wanted to focus on ground 5, because this is the one that the trial court also had a real concern with. And that is, during Detective Ernie's testimony, each of these images and videos, all 30 of them, were shown to the jury. So the jury was already exposed to this. But then the state wanted to present Dr. Bell. And they had a valid reason for doing so. One of the enhancement that was charged in this case is the state had to establish that at least 10 of the images involved children under the age of 5. But at the time of Dr. Bell's testimony, the defense objected and said, you're not going to let them republish all of these images, are you? The jury's already been exposed to these images. And the trial court seemed to agree with that. The trial court even went on to say, is there any way I can convince you to have Dr. Bell review the images? This is page 422 through 428, review the images and simply tell the jury that he believes some of them were under 5. The prosecution said no. There was then a discussion about, can we stipulate that these images involved at least 10 children under the age of 5? And the defense did stipulate, and the prosecution said, we don't have to accept that stipulation. And ultimately, each and every one of these images was re-shown to the jury during Dr. Bell's testimony. It was
okay, Mr. Ufferman. So if we take that statement as true, then the jury saw these images cumulatively twice, each
Correct.
image twice in the trial?
Yes.
Okay. All right. And so is it your opinion that these images became in any way a focus of the trial?
Certainly by doing that, because Your Honor,
those images are what the trial was about. I mean, so I don't know how they aren't going to be a focus of the trial. And I don't know how we would write an opinion that says that showing images twice to a jury constitutes reversible error. How do you write that opinion, Mr. Ufferman?
9403 says 9403 says it's improper to allow the needless presentation of cumulative evidence. It's that simple. This evidence had already been presented to the jury. The republishing was overly prejudicial compared to any relevant value. So
the evidence was presented to the jury the second time, specifically in conjunction with the expert's testimony. Is that correct?
That is correct, but nothing would have prevented, just as the judge suggested, Dr. Bell, you've reviewed the images in this case. Is it your opinion that at least 10 of those images involve children under the age of 5? Yes. And by the way, in addition to that, the defense stipulates that there's 10 or more images under the age of 5.
Well,
Do you have any cases where evidence that's already admitted, which these photographs were already admitted into evidence, are somehow excluded under 403 from the jury seeing them ever again? I mean, during deliberations, they had the opportunity, and nobody knows if they looked at them again. But do you have any cases that say once a picture's in and looked at once, that's it, you can't look at it again?
It's my understanding that and if I'm wrong, I apologize, but it's my understanding these images did not go back to the jury room. It's having handled a handful of these types of cases, I can tell you the state knows exactly what it's doing. I just did a resentencing last week in the Bourbon case, and the state tries to re-mention the names of the titles, show the images as many times as they can, because they know of the prejudicial impact that it has. And any court has the responsibility to make sure the jury decides a case based on the facts and the law, not on some emotional or visceral response to outrageous or offensive images. And the trial,
but Mr. Ufferman, the facts and the law would include also the evidence, and the photographs were clearly admitted into evidence. So why wasn't the jury entitled to have all of the evidence, assuming we're not talking about something unreasonable, like in a products liability case, a car, but the photographs were in? Why wasn't the jury allowed to consider that in their deliberations on their own?
It's no different than having a gory autopsy photograph. They may be introduced one time by the state during the medical examiner's testimony, but to show it over again to a jury would at some point become needless presentation of cumulative evidence, and the prejudicial value would outweigh any minimal probative value.
Wouldn't your burden on appeal be an abuse of discretion?
Yeah, and so again, let me focus on what the trial court. Yeah, the answer is yes.
Keep in mind, you're into your rebuttal time.
Thank you. The trial court in this case on pages 423 and 429. Let me just say this. I don't know if you watched the jury at all during any of that. The point has been made. If that's if they're willing to stipulate to that amount, do you want me to put them through that again? Judge goes on. And I understand a lot of these folks in this room, this is what you do on a day-to-day basis. The jurors don't have that level of seeing this on a day-to-day basis. This is unique. I would submit that these types of images in a child pornography case, because of what the judge said in this case, it is unique. And you cannot allow the needless presentation of this type of extremely offensive and prejudicial evidence. And again, the judge in this case felt like, oh, I can't accept the stipulation, so I have to allow him to present it. The judge seemed to miss the point that it had already been presented. The jury already got to see these images. So if we were talking about, oh, the state can't put the images on at all, yes, I wouldn't have an argument. I acknowledge the state is allowed to put on these images at least one time during his presentation, but to put them on twice because of the offensive nature, when there's no disputed issue and the only purpose is to get an emotional response from the jury in a case where there was a viable theory of defense, that's inappropriate.
Let me change the chat. Well, if we can, and we may need to give you an extra minute, but talk to me quickly about the JOA as it relates to the images that were only on the CDs. Was there any proof that he viewed those images, since they were not on the desktop and were not on the laptop?
No, and there's even a mention in the state's answer brief on page 25. The file was no doubt viewed in thumbnail version. That's a state
no testimony of that either, is there?
No, that's complete speculation, and it
that's
would
all.
matter.
I don't want to take any more time. I just want to make sure I hadn't misunderstood, because I've got another guy I'm going to ask about it in just a minute.
Well, and the last point I'll make about that is it would have made a difference in this case. Of course, I know this court would ensure that no client is convicted of a single count, even if there's multiple counts that they shouldn't be convicted of. But beyond that, my client in essence got the minimum on the score sheet. The minimum was somewhere around 33.5, and my client got 35. So taking these images out would have an impact on the sentence in this case. I'll reserve the rest of my time for rebuttal. Thank you.
All right, thank you, sir. All right, Mr. Coriante.
Yes, thank you, Your Honor. Good morning. I'm representing the state of Florida. And if we want to go to the thumbnail question, I'll be glad to. It was mentioned over half a dozen times in the transcript. However, as the defense attorney called it a thumbnail, and I call it a thumbnail, it was described by Detective Ernie as an image icon. That's what these were. And you can set, as everybody knows, you have icons on your desktop. And until you click on that icon, that program's not going to open. But you know what that icon represents, and you see a picture of the program's logo. The same way, if you put a CD into your drive and you try to upload from that CD, when you click and you open that, image files appear in a thumbnail or image icon fashion, So you know what you're looking at.
Maybe they do and maybe they don't.
We don't know I mean, counsel, the problem I have with the icon testimony, and I looked everywhere I could, and appellant's counsel's correct, and you've conceded, he never uses the word thumbnail. And when you talk about icon, you know, you look at the icon for the Word program is not a document, it's a letter W. The icon for all kind of programs are not images of what's inside the program. So how do we know what he was talking about when he was talking about an icon?
Well, okay, the defense counsel even described it as an icon. Well, I mean, as a thumbnail. It's in the transcript. It's an interchangeable word, but when you set your Explorer, when you open a file, you either get a file name, which would indicate what kind of file this was, or you'll get an image. There's only two ways to put a CD in and look at what's on it, not open files, but look at what's on it. This man had to know either by the name, if he had it verbed in that way, or he had to know because an image of the icon would appear. You can set it for small, medium, or large. It's described in 2 pages of transcript clearly by Detective Ernie. He also said, you
Let's go
won't
ahead and
get a
change
link
that.
file.
Okay, that's fine. Let's also change a little bit now. What about there were 6 images in 6 counts that are only on the CD, and I saw no proof anywhere, and in your answer brief, I don't see a real direct response to it. What proof was there that he saw those 6 images?
Well, those 6 images, my understanding is that all the images were on the CD. Somebody picked certain images from that CD. So to pick and choose between one or another, you would have to know which ones you were going for.
That's an assumption. There was no proof of how it was done. I understand that there was testimony that in order to put it in the sub files, you'd have to go through that. But if there were 50 images on there and say he picked the first 30, just hit 1 through 30, shift, and boom, there you go. Because we now know how to do that kind of stuff with documents. How do you know he looked at the other 20 if there were 50 on there? There was no proof of that.
There was evidence that the files had to be manually manipulated, Your Honor. And
I understand to get them onto the laptop, they had to be manually manipulated, and perhaps to get them onto the desktop. That's not my point. My point is there were 6 images that the detective said the testimony was clear, only on the CD. Is there any proof as to those 6 images? I mean, I understand that's not the big part of the case, but still it is 6 counts and time in prison.
I believe that the evidence does show it because there were files from each CD. So that CD was put into one of the computers, and it had to have been able to be viewed either as his theory of defense is it was an accident. I never saw them.
I understand that.
And so that defense is okay.
Counsel, I understand that. I understand that. The jury understood it. The jury didn't buy it, obviously, or we wouldn't be here. But again, and if we're not going to get an answer to the question of what proof was there that those 6 images were viewed, then that's fine, and go on to your next point.
All right, Your Honor, I can only say that in order to upload all of them would have had to have been opened in a fashion by title or by name before he could pick from one of those and move it up.
If you want to keep talking about it, what evidence was there of how many images and file names would have come up on the screen at a time?
There was no evidence as to how many.
Then how do you know he had to have seen those 6 images?
All right. I think that it's an intent issue. It's a knowledge issue that can be proven just by the constructive evidence surrounding how all this was done. That's the best I can do. I think that the evidence was clear enough that he had to know what was on all of those. But
okay, all right, let's move on. That's your story, and you're sticking to it. Let's talk about the 2 images that were discussed by the detective that were uncharged.
Okay, again, that refers back to the link files. So I've already explained that he was talking about a link file. He was not talking about an image file. I also clearly put in the brief how it was broken down didn't say an uncharged crime. He didn't say an uncharged photo. All he said that there was a link to something that he didn't see. And that was not evidence of an image, because you need an image to have a corpus of a crime. There were no images. Link files don't have dates. I mean, technically, we don't have the date on this link file. So we don't know what he was referring to.
You're making Judge Edwards's argument on those other pictures that were on the CD. You're making that argument now for the testimony from the detective then, right?
No, I'm not making that same argument. I'm saying that the detective is the one who explained what link files were. And he said, and then he was questioned as to what they refer to. It says they show a file that's been recently opened. They asked whether they, and I mean, the defense's point was they wanted to be sure they got evidence that none of the 30 files charged were linked, had link files. And it was clarified after that. That's what the question was. And it didn't say, and even the judge said, I didn't read it the same way as defense attorney said that this was an uncharged crime. I read it as this is a link file.
Well,
to
you might
an
not,
unknown image.
might not have read it that way, but it certainly was susceptible of being read that way.
It's possible, but it was cured by what was allowed afterward when the defense attorney said no link files were ever associated or shown to have accessed these 30 images. Done. That's the point. And that was the concern. So they can only convict him of those crimes charged. He's talking about unringing a bell. This bell had clamored for 30 pictures and 2 linked, vague image icon files that possibly a jury could think were 2 more pictures. Could not have possibly.
Well, certainly when the detective used the term, and I might not have it exactly right, but child exploitive titles, that's not just, oh, geez, I found a couple of fishing pictures or something. It's, you know, I saw 2 child exploitive title files that aren't among the 30 here. And I agree, it was vague. I mean, it's easy for us to say it was vague. It's easy for the trial judge to say it's vague. We have no idea what the jury thought of it. And it kind of takes me to my next question. What about this cyber tip from the National Center for Missing and Exploited Children? I mean, to me, that certainly, I kind of buy in a little bit. I understand what the defense or the appellant's talking about here in terms of kind of makes it look like this guy was being investigated by the National Center for Missing and Exploited Children, which, you know, makes it sound like he's a big player. I mean, it just that's got to be somewhat prejudicial, don't you agree?
Somewhat prejudicial, except of course it didn't name him really.
Oh, please. That's almost insulting to us. You think that Detective Gonzalez is talking about that randomly? I'm Mr. Corrente. You know that
Paul L.
All right. His last name isn't L. His middle name isn't L. It listed an IP
it's Elias,
address.
Isn't it? It's Elias.
Elias, yes.
Okay, so it was close enough that the National Center and the detective figured out who it was, but the jury's so stupid they can't figure out who's sitting at the counsel table.
A third grader, Mr. Corente, could have figured that out.
Okay, let me go back then to, this came from Yahoo. On cross-examination, it was brought out to tip. Actually came from Yahoo.
Detective Gonzalez testified that there was a tip from the National Center for Missing and Exploited Children, and that's what started the investigation of this particular individual. And that's absolute hearsay. And this idea that it was admitted to show, his state of mind is just absurd. And we've written about that over and over and over again. And yet these prosecutors have no understanding of what we're saying. You can't admit that type of information.
As a whole, I agree, Your Honor, with everything you just said. That's not something that's appropriate to be brought in. And they haven't been listening, and I agree with that. I have no qualms with that. I do have the argument here I'm making in this case, and it's the case law that says that hearsay really has to identify appellant. If you think Paul L. is close enough to Paul Carl Elias, all right, we go past that. There was nothing else that associated the defendant with these pictures except the Paul L. They had an IP number address. It didn't say that guy over there did it or that it was committed here and I saw what happened. All it said was, and it was from Yahoo, if you want to go to 341 of the transcript, on cross-examination, he explained that. He said it comes from Yahoo. They see something suspicious. They deactivate the account. They tell the National Center, who forwards it to us. And so then we look, but all we have is a username, which was not Paul L. or Paul Elias even. They had two Yahoo accounts not attributed to the defendant, and they didn't have an address. They had nothing pointing it to him. All of the cases that say, yes, this is hearsay, even though there was a business record exception too for the Yahoo, which would be an exception to the hearsay rule, even if this was hearsay, even if it was inadmissible, it still has to say the defendant did this crime. And that wasn't shown until the search warrants and everything else were filed with Yahoo, and everything came back and said, here's the address, and it said only someone in this house using these email addresses were the ones that had associated with this account. So it could have been multiple number of people in the house. It didn't really, it's not the same as the hearsay that said, yes, I received a tip that John Doe was driving around in this license plate car selling drugs. It wasn't that someone committed a crime. It wasn't that the defendant committed a crime. Is that a crime was committed? Here's how we're investigating it. And I really believe, Your Honor, that even if it's hearsay, and yes, as I said, I agree, they don't need to go into the background like that. They can say, I got a tip. Here's what I did. I agree with that, and that would have been preferential here. But at least in this case, it wasn't a tip that said Paul Carl Elias was the man associated with this case and had filed.
Let's talk about some other conduct of the prosecutor in this case. Certainly, I know that you have taken the position that it wasn't properly preserved, and I'm not unreceptive to that argument. But would you concede that the trial court was wrong in finding that it wasn't a discovery violation?
No, I wouldn't concede that it was a discovery violation because
really? So the guy comes in and he testifies at deposition. No, I have no idea. I don't know anything about this Flickr program and whether it has an auto upload function. And then between that deposition and trial, he gets a Flickr account for himself. He examines whether it has an auto upload function, and then he comes into trial and he testifies about that. And you think that isn't a discovery violation?
Well, when you put it that way, it sounds very convincing. But I do believe that this had to do with regular research that any person could do. And it was something that he did because he was asked on deposition, do you have an account?
That's fine. But why doesn't the prosecutor then have an ethical and legal obligation to disclose to the defense that he's done this additional research, he's done this additional investigation, and the substance of his testimony has changed from that of his deposition and now includes A, B, and C?
It could be understood that way in this case. I'm not disagreeing with that. I just believe in this case, if it was such a surprise and if it was such an impact, you say he was completely ambushed. Well, Detective Gonzalez testified, two witnesses before Detective Ernie, and said, and he asked several questions about how you set up a Flickr account, which Detective Gonzalez did not know, but he said Detective Ernie does. Right then, that should have set up some flags.
Well, maybe, but he had he didn't know what Gonzalez knew about Ernie's knowledge necessarily. And he knew he had a deposition that where Ernie testified that he didn't know about it. So that, maybe that should have set off a flag, maybe not, but that's not terribly, persuasive. I'm just concerned that we've got, this prosecutor who is off the rails.
Well, I agree that when you're supposed to disclose material changes in testimony or opinion. This wasn't an opinion. This was, did you look at how to do Flickr? No. Did you look at how to do Flickr? Yes. Here's what I testified.
In his deposition, he was ignorant about Flickr other than knowing it existed. At trial, he was Mr. Flickr. He explained how it worked, how you upload or can't upload, and this, that, and the other. He went from somebody who knew nothing to somebody who was the expert on Flickr for the state during the trial.
But
as far as Gonzalez, as far as Gonzalez saying, "Oh, Ernie knows all about it." Boy, if I was a defense lawyer and I had that depo, that's great. Gonzalez is dead wrong because Ernie says he doesn't know anything about it.
Right. And so then when Detective Ernie says something along those lines, then you can jump up and do that. I'm saying that this was something either expert could have testified to. We had two experts. The defense expert could have explained all of that. The state's expert.
Unless, I'm trying to think back to my first criminal law class in law school, but I seem to recall that the state has the burden of proof in these cases. Has that changed?
No, it hasn't, but there's cross-examination does show, you could cross-examine Detective Ernie, or you can direct examine him and ask him those questions, or you could ask Detective Gonzalez, or you can ask the defense expert.
Mr. Corriente,
experts being called on.
Mr. Corriente, it's also a continuing obligation on the part of the state when any new evidence comes up during the course of discovery, correct?
Correct. Material evidence, a material change in testimony. That's the bone I pick with this.
The material evidence in this case we're talking about here went to the central theme of the case, which is, was it intentional or was it an accidental download? Is that correct?
That's correct. Was it? Yes. But that's not the only way. His theory of defense was that I don't know how it happened, that I didn't do it. I didn't
explaining away. You're totally attacking and going precisely for the defense. And that was the theme throughout the discovery. And you knew it was going to be a big deal, you being the state, that it was going to be a big deal at the trial. And that's why the witness went to such effort to educate himself prior to taking the stand about the actual defense of the case, correct?
The Detective Ernie testified in order to get those images on there. This had nothing to do with how you set up a Flickr account, really, but you have to click on each image and you have to send it up.
Well, there
was no dispute about that.
Presence or absence of an auto upload feature is critical.
Well, it's not decisive, though, because there are other programs other than all Detective Ernie testified to was that Flickr had an auto upload. There are other programs, and as the defense expert mentioned, that there are programs that do it. And this was actually a third party.
That he didn't know he needed to look at an auto loader until after the detective testified during the trial.
Well,
and then the stellar prosecutor then attacks the credibility of the expert because he hadn't done it earlier. I mean, it just, to me, that is just completely unprofessional.
All right. Well, again, I don't think I didn't think it was material because I didn't see the mechanics of the Flickr account and to be important when there were like, and anecdotally, that's why I placed in my brief, there were nearly 100 million people who use those programs. And even Ernie testified, it's like several other of these programs that everybody uses. If you haven't uploaded a picture, I say you would be in a minority and wouldn't know that you click on that picture and then just say forward it to the cloud.
Well, Ernie didn't know about it. You said everybody knows about it at first. Ernie didn't know anything about it.
He assumed he was an expert for the sheriff's office.
He assumed it worked like a couple other programs he mentioned in his, I think in his statement or in his deposition, but he didn't really know. And then he knew they were going to ask him again and didn't want to look like a blithering idiot, perhaps, and said, well, I did try to do it. I said, my son has one. I mean, it's
I don't
ubiquitous thing.
how you can possibly say that the trial court didn't err in finding that this wasn't a discovery violation. I understand arguing that it wasn't preserved, but I just don't understand your argument that this wasn't a discovery violation. Can you explain that again to me?
Okay, well, now how can I skip to, was it inadvertent and was it prejudicial? And
Well, no, we're going to start because
We're
the
gonna
trial
start-
court made a finding that it wasn't a discovery violation. So
Well,
we're going to start with that. Was this a discovery violation?
I don't believe it was a material violation. No,
Was
how
this-
you upload pictures is still ubiquitous and,
No. You have to answer the question that I'm asking you, which was it a discovery violation?
No, the judge ruled no.
Okay, there you go. Then you don't need to say anything more about it.
Okay,
Okay, thank you.
all right, thank you, Your Honor.
All right, Mr. Ufferman, we'll give you an extra minute or so. So you got 3 minutes and 20 seconds.
Thank you, Your Honor, and may it please the court, and I won't belabor these points. I won't waste any more of the court's time. This court, all three judges are.
Mr. Ufferman, it's never a waste of our time. We're dealing with someone's liberty, someone's freedom. We don't consider that a waste of time at all.
And I appreciate that, and this court is extremely knowledgeable about each and every one of these issues. So I thank you for that. The question was asked earlier: how do we get these prosecutors to listen to us? And I can't promise that there's anything you can do that will get the prosecutors to ultimately listen, but there is one thing you can do that can attempt to get them to finally get the point regarding these claims. You can issue an opinion that repeats that it's improper to fail to disclose to the defense when a state expert, who in this case was presented as the forensics expert, says he's initially not knowledgeable on an issue at all and then does subsequent research after the deposition but prior to trial, and then the state is clearly well aware of that and fails to disclose it to the defense, resulting in an ambush at trial.
Well, Mr. Ufferman, actually the issue that I was referring to was allowing testimony,
Hearsay.
substance of the testimony about the tip.
You can again repeat that the state of mind of the officer regarding the background of the investigation is not relevant. It's not an issue, and it is clearly hearsay to tell the jury that some other investigative agency was investigating my client, and by all accounts, the jury clearly would have known that Paul L. was referring to my client. You can repeat that again. And then ultimately, you can also make sure that the same defense expert state expert detective who failed to disclose his change in opinion and additional research doesn't mention uncharged conduct during his testimony. Ultimately, this is all that I do for a living. I only represent people in criminal appeals. And people ask me, why do you do this? How do you do this? And I say, our system only works if my clients receive a fair trial. I can tell you that because of each and every one of these issues, there is no way that my client received a fair trial in this case. There's no way this court can put confidence in this verdict because of the way that all these errors were caused by the prosecutor, and this court should give my client an opportunity to have a fair trial as a result of those errors. Thank you.
All right, thank you. All right, we'll be in recess until our